Hello, everyone, and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to Rajat to get us started.
Thank you, Mona. Thank you very much. So, good morning, good afternoon, and good evening to everyone who has joined us today. So, my first thanks to Global Arbitration Review for hosting and convening this masterclass, and to my colleagues at Mason for helping bring it together and put this panel in front of you. By way of introduction, I am Rajat Singla, a partner at Mason, where I work as a delay and quantum expert on both construction and technology disputes. Over the past decade plus, I have sat at the sharp end of exactly the kind of disputes we are going to discuss today. We are going to analyze what went wrong on these troubled projects, by how much, and at what cost. And obviously, we'll explore how to prove all of these things. Now, that's precisely why this topic is close to me and probably to all of you as well. And I'm glad to be moderating this, not on the answering today. We have four people far better placed than me to take each of the issue we are going to discuss today on this topic. I'll be steering the conversation around the issues for this masterclass. So to start with, I'll introduce the topic itself. So what are IT developmental disputes? These disputes arise from the projects which are meant to deliver a new system, platform, and a piece of software that instead end in delay, deadlock, or claims. These disputes are everywhere, and yes, they are very expensive to resolve to, and they are notoriously hard to prove. And our title today puts it very plainly: what goes wrong and how the experts prove it. Over the next 90 minutes, we'll trace the arc of these disputes, how they actually unfold. We start where the trouble is actually seeded. That's how the scopes are defined in the IT projects. We move to the milestones and explore how anyone tells whether a project was genuinely on track or not. Then to the acceptance testing, which is a blurry line between and not done, and we'll see the I would say the technicalities around it. And then we close with the expert evidence itself, what a forensic experts looks for and what actually survives cross-examination in front of a tribunal. What I hope for the audience that they will take away from this masterclass is a practical feel for where these disputes are born, what the warning signs look like while a project is still live. And it doesn't matter whether you are instructing experts, advising the parties, or sitting as a tribunal. It is important to understand the evidence and the nitties and gritties of the things which separates an evidence which is persuasive and the evidence which quietly gets set aside in the proceedings. So we have genuinely a cross-border and cross-disciplinary panel with us to explore all those things. Now I'll introduce our distinguished panel. First is Mr. Sebastian Wolbeck. Welcome, Sebastian. Sebastian is a partner in the litigation and dispute resolution practice at Dentons in Düsseldorf. He sits on both sides of the table as a counsel as well as an arbitrator. His focus is complex commercial disputes in the technology and energy sectors, including construction and post-M&A disputes. He advises clients on project, contract, and claim management disputes. He is regularly recommended for dispute resolution by leading German publications. For today's masterclass, Sebastian opens us today with a provocation, a very interesting thought that IT disputes have more in common with the classic construction disputes than we might think. We'll explore this angle with Sebastian. Welcome, Sebastian. Next is Ms. Tanya Sharma. Tanya is a disputes lawyer with over a decade of experience across commercial litigation, international arbitration, and cross-border disputes. She is in-house at Wipro, that we all know is a global IT services company. She handles disputes and litigation works spanning India, the Asia Pacific region, the Middle East, and the African subcontinent. She began in law firm practice, appearing before courts, including Supreme Court of India, before moving in-house. Tanya will bring a perspective from inside the supplier side while the project still lives. Welcome, Tanya, to this panel.
Thank you so much.
Then we have Mr. Jonathan. Jonathan is a litigation partner at Curtis. He specializes in securities, regulatory, and commercial disputes across US state and federal courts. He represents major accounting firms, financial institutions, and corporations, and has appeared before agencies including SEC and the Department of Justice. He also advises on cybersecurity and data privacy and brings international arbitration experience under institutions such as ICC. For today, Jonathan is our window on how these disputes play out in US litigation, and he will lead us on the milestone fight. Welcome, Jonathan.
Thank you, Rajat.
Then, lastly, we have Mr. Sykes. Tony is our technical anchor. He is a distinguished technology expert with over 40 years in the design, development, and testing of hardware and software systems. He's a chartered electrical engineer and a chartered IT professional, a fellow of the Academy of Experts, and a member of its council. And he's a founding committee member of the Society of Computers and Laws IT Disputes Group. He has given evidence in numerous international arbitrations in front of tribunals and the English Technology and Construction Court. Tony is the one, I must say, who gets handed the wreckage and has to prove what actually happened in the project and has to prove it in front of the tribunals. Welcome, Tony. Thank you all for joining us with the panel.
Thank you. It's good to be here.
Thank you. So now I'll steer away from the introduction and we'll start with the crux for which we all have gathered here. I'll start with the first issue and we'll explore the interesting thought Sebastian has put in front of us. So Sebastian, you see IT development disputes as a close cousins of classic construction disputes, which are basically over-promising, delays, defects, etc. So my question is, where is that parallel which you have drawn is strongest and where does it break down?
Okay, perfect. Thank you, Rajat. And you said it's a bold statement or controversial maybe, but I actually think that the comparison is, through my lens, to my disputes lens, very fitting. However, Tony, I think maybe you have a different opinion on that from a technical point of view, but maybe let's break it down from my perspective, which is, I must admit, very abstract, right? From my perspective, both types of projects are typically projects that involve specialized companies with the intention to deliver a very complex product. And that's, as you see, it's as abstract as it gets, right? But whether it's an oil shale plant for the energy disputes, construction disputes, on ERP system for the IT dispute. For me, when it comes to the dispute, it does not really matter on this abstract level, because in both worlds, you need highly qualified individuals that work together within a defined time frame and a defined budget to materialize a very complex product. And in both the IT projects and the construction projects, you have a very similar contractual project governance. That means how the projects are planned, how they are monitored, and how they are managed. And in both scenarios, once the project starts, and those different groups I explained before, and the individuals start working together, putting basically into being what was only a thought before, what the parties thought of before, during the actual execution of that project, the requirements that were only a thought before evolve and expectations might shift. And at some point, it might show that the stakeholders had different expectations from the outset. They just didn't know about it, or some kind of other thing, some other issue with the interface between the different groups and stakeholders emerge. So that's why in both construction and IT projects, when something changes, change orders, delay notices, acceptance procedures, they all play a very central role in during the execution phase, but also in the dispute that might come later.
Yeah,
And
that's interesting to know. Yeah. Yes, Sebastian, you were going to add something more. Yes, please.
maybe let me add that in both worlds, the IT and the construction world. From our experience, you see that the disputes tend to emerge around the same themes. That's basically, as you mentioned already at the beginning, it's delays, it's defects, or it's basically disagreements about the scope or the responsibilities, right? And you said you asked me where this analogy is the strongest, and I think that's the strongest point. But as you all also already hinted, there are some weaknesses because if you look at the evidence side, when it really comes to a dispute, I think that's where both projects and the disputes differ a bit. Because if you walk on a construction site and you have, for example, a failed pipe, that's something that even I can see as a technical layman, so to say, right? I see that that the pipe broke and that it somehow interfered with the overall system, right? I also understand that this pipe can be preserved and then examined by a methodologist or something and tested, and you see why it broke down and what the impact was on the overall system. I would say with a view to software, for most people, that's different because as an external counsel or arbitrator, I cannot simply look at a piece of code and on my own identify whether there's a design flaw or whether there's a defect in the architecture. I cannot pinpoint to it. And someone with technical expertise like Tony needs to explain to me what is wrong with the line of code and why it matters to the overall project, right? And
No, so very well
before
put.
you,
Yeah.
yeah, sorry?
No, I'm saying it's very well put. You have drawn a parallel as well as you're diverged from your own view by saying that it there is a difference in terms of evidence preservation. So I'll definitely take these two things with two of our speakers. But yes, I'll let you add things you were going to add actually.
Yeah, okay. Yeah, as I said, so that's only the evidence that it's hard for a layman like me to identify the defect itself, and someone needs to explain it to me. But then the parallel I made up basically with a view to construction projects breaks down even a bit more when it comes to the evidence preservation because well, it's basically clear how do you preserve a broken pipe, right? You just put it in a bag, send it to a lab, and then it's preserved basically. But with a view to code and system configurations and development environments that are often the source for the defects in IT disputes, it's very different. You have to figure out how can you preserve the the defect so that a tribunal that are most of the times not IT experts, so real technicians understand that that is really the code that was faulty and it was somehow preserved and not altered with in some shape or form. So that's why I would say that in IT disputes, the central question is not so much, or often the central question is not, is there a defect, but was it preserved? Is it really the actual defect that we see there? Right?
Okay.
So that's why I think overall I would say that then the evidentiary trail is often way more fragile and technical when it comes to IT disputes.
Very well said. So, Tony, as Sebastian referred to you as well at the start, that is Sebastian actually right that what goes wrong is essentially the same in IT dispute or a construction dispute, or is there something about IT delivery that the construction analogy misses?
Yes, it's very interesting because he's set out the similarities, And I probably agree with most of those. We'll go through them in a bit more detail in a minute. And he's picked up some of the key differences, but the biggest one of all for me is that, and he's touched on this, is preserving the system. If you've got a construction dispute, or a construction project that's going wrong, and it stops, then you can take photographs of it and you can record things in that way. When a software implementation or a big technology implementation stops, and there's a repudiatory breach or whatever, it's very difficult to preserve the environment on which to later prove that the software was or wasn't working, or was exhibiting defects or whatever. Very hard, because very often the hardware upon which it's working is owned by the supplier at that stage, and possibly partially delivered, but to reproduce it sometimes years later is very, very difficult. The things that I think I agree with him. Scope creep and the ability to manage that is the same really in both construction and IT. The subtle difference, though, is that if you are changing, let's say, the number of floors on a building, or putting an extra room on the side of a house or something, or a new lane on a motorway, well, that can be specced up. It takes a long time, and it all gets to be agreed. With software, it can be very often the case, and it's always a mistake in my view. But very enthusiastic software developers can sort of say, "Yeah, that's no problem. I can quickly do that," and they don't follow the change procedure, and they don't do the risk analysis, and they make a little change, and that comes back to bite them months, sometimes years later. So it's very easy to change software. It's not so easy to knock down a wall and move it. That's one of the big differences. It's interesting. I'm doing a big SAP dispute at the moment, as will be well known to somebody on this call. But it's funny, because SAP, and increasingly now Microsoft Dynamics, use the expression blueprint, which is the sort of specification for how the software is going to work, what it's going to do, and what's required to get that to be achieved. And of course, blueprint comes from the construction industry. It's starting to be used by Microsoft themselves in their definitions of their specifications. So it's another sort of tying together of the two areas. I would say probably the key differences. There's often a dispute about IP, intellectual property, in software, and big technology disputes, because software is either owned by a third party, or the client, the supplier rather, owns the IP. It's rarely a problem, I would say, in construction disputes, but I'm happy to be proven wrong, but that's my observation. Little things like, I think he's already said, defect identification. It's obvious in a building often, as you say, a broken pipe or a wall's, has got cracks in it or whatever. In software, triaging software defects is really rather hard. And once you have triaged them, you can guarantee that the client will triage something as complete, stoppable, irreversible, must be fixed immediately. And the supplier will say, well, it's just a trivial little blip we can easily fix later on. Never quite possibly that dramatic, but there's always an argument about how serious a defect is. Whereas I think in a building or a construction project, it's possibly more obvious. I think that's probably it. The only thing I would say, and it's more semantics than anything, but very often construction projects work off specifications, and IT projects and technology projects work off requirements. And while they are more or less the same thing, they're not always. And so that's possibly a point to debate later. I don't know, but it's just a food for thought.
Thank you, Tony. And I think you have made a very good point, and you have basically seconded Sebastian's point that the real difference lies in the evidence preservation. And I would take this with Tanya that from inside a tech supplier, what evidence you think tends to slip away while a project is still live on, or I would say still limping towards, even before somebody thinks on the project, we are moving towards a dispute.
So I think we are moving towards a dispute only comes in when the money stops coming. Before that, there is a little hint. There's no hint actually that where we are heading to. So I absolutely agree with Sebastian and what Tony said. In construction, disputes is a little more tangible as compared to an IT dispute. It's more visual. There is, there are physical records. You can see what happened or did not go so well. Whereas in IT projects, especially the ones that go on for 5 years, 8 years, which are divided into many different phases, there's an implementation, there is a testing, there is a maintenance phase. There, the usual communication is only through emails or some trackers or some governance meetings, and most of them track the actual work that is being done. Mostly so, just covering the milestones and broad level work that is being covered. So I think the places where the evidence slips away first is a lot of verbal communication. Just like how Tony said that, a software developer would say that, I can fix this for you, I can do this for you. And they will go ahead and do it, even though the contract has a procedure for a change request or anything that requires an approval. But it's lengthy, and I'm sure it also involves the legal to be involved. So they try to see that maybe we can be done with it, and most of the times that's where things get stuck because there are no proper approvals. There is no proper how to proceed, what is expected. A lot of times, even the fee part is also not very solidified. So, the business is in a good mood. The relationship with the customer or the client is going well. So you don't see anything that could be a potential problem. So you go ahead and do the work, and a lot of times they just don't agree that it was something beyond what was expected. That is one. And another thing is that in most of these projects, there is a tracker that is shared. Some, some customers want it monthly, some want it quarterly, some want it even weekly. So I've personally seen these trackers. These trackers only talk about what this, the service provider is doing, but doesn't talk about any dependency on the client, the environment, or any kind of, dependencies that the client has to provide so that we can act upon it. Now, this also, the service provider will not communicate in the email that, okay, you know what, this is pending on your end, so we're not able to move ahead. So you'll keep it mellow, you'll keep it in a way that it's more amiable. But when the dispute happens and you look at these reports, these progress reports, you cannot find anything that will substantially point towards that the project was derailed for so and so reason.
Yeah, thank you, Tanya. And it actually raises one point that we hear more than often now, and the provider always says that the client never gave us stable requirements. And I can understand now that uh, when there is no documentation of the requirement as such, it will always look unstable. And when the dispute comes, this, I would say it's a rather convenient defense rather than a fair defense that the provider says that the client never gave us stable requirements. So it actually leads us to the scope creep issue, which Tony has highlighted that, and Sebastian also said that it is similar to the construction disputes. On the scope disputes, I would again ask you, Tanya, that most of these disputes, when it is scope dispute, they are seated right at the start. It's just that the stakeholders doesn't know about it until they actually encounter such scope creep. So, from the ground, how do you see that these scope problems actually begin, and how anyone becomes aware that it is actually happening at that time?
So, like I said, nobody gets to know it's happening at the time unless the payment stops. That's the or there is a breach notice, either of the two. But going at the scope part, um, these days the contracts are negotiated at a very exhaustive length, especially the scope part. Months go into deciding the scope, any kind of deviation that happens. So I don't feel that the beginning or the scope that is defined in the contract is where the problem arises. The problem usually arises when there is new things that the client wants, or something that they would want to work a little better in a different environment. And if this is a back-to-back arrangement, then the service provider is under much more scrutiny, because the payments are also dependent on the main customer, which with which you have no direct contact. So I think in the beginning, everyone's very optimistic and there is pressure to deliver. So whatever scope is defined, business is generally upward of how they're going to do it. Now, when during the project, like these are long duration projects, there could be a different process that they require, or a different environment, or maybe they want a different technology that would support, or a different methodology before which they did not identify. Resources could be a different kind that they want to support their project. And most of this is not documented. Again, because in the moment it is happening, there is so much pressure to complete the timelines and to go ahead, that this is not the thought that comes to a technical person's mind, as in the business person or the salesperson. It doesn't come to their mind. Their interest is that we have to get this done, and we can move around a little bit and do what it is, and we'll write a mail that we are doing this, and very vague email. It would not be very clear cut of what is being done. And a lot of the customer dependencies are never highlighted. I'm repeating this again because this comes out in the later stage when you're not able to prove it, that we did the work with the best intentions, and that's what we were indicated to do so. But since it's not coming out in the document, why it got delayed, it becomes a problem for the service provider. And this is mostly the stage where people are trying to be accommodating and trying to figure out ways to make the project as smooth as possible. If they're in timelines delayed, work around that. But I think the biggest issues happen around the UAT, the testing time. When it comes out in the open, no reason, or you don't know what exactly went wrong, but the product or the services did not come out as there was an anticipation or expectation around about it. So testing also takes a lot of rounds. Some customers want that a third party should come and do a independent testing. This is quite common with the government entities, because they would want, because of the public nature of the services that are being used. That gets one more problem into the picture, because then now you have to satisfy the third party also. And of course, you're satisfying the client. And even though both parties were right, in the end, you'll not be able to understand where this all started taking a step side, or where it started digressing. It'll only come to your knowledge, oh, it didn't work out.
So yes, and to pick from what you said that sometime it happens you'll write the client writes a very vague email of its requirements or what it's supposed as asking. So this vagueness actually directs me towards Jonathan. So Jonathan, how does this vagueness plays differently in US litigation? Is vague scope more often a gift to the defendant or the claimant? How does it play? We just want to know that.
Well, I would note first, Rajat, most of these cases end up in arbitration, as we know, most of the parties use arbitration agreements. But in the exceptional case where it is in front of a U.S. court, they will look at it the same way a tribunal will. They will look first at the agreement, the services agreement. What was the scope of work that was agreed to? What was the outline of basically how this IT project would go forward, and what was the tracker, deadlines that were required to be met? Vagueness does not help anyone. Certainly for the claimant, if they are trying to argue that the IT provider did not provide a certain feature, it will be hard to argue that if it's not set out in the scope of work from the very outset. So that's why it's so important at the very beginning for both the client and the service provider to be as specific as possible, not only about what IT, features will be implemented, but how they will be done over time. And I anticipate actually that this will become even more prevalent in disputes with the advent of artificial intelligence, because there will be a number of projects now that will ask for an AI feature without anyone really understanding what AI, how AI works and how it exactly will be implemented.
Yeah,
I
yeah,
think Tony
Tony.
has a
So,
comment.
do you have any comment on what just Jonathan said, or to what Tanya said?
Yes, I was just going to add that on scope and in fact on the differences between construction projects, when you're working with an agile methodology rather than the traditional waterfall, it brings a whole different aspect to scope, because the scope is in the backlog. You list out all the things you're going to do, but it's very, very easy to add and remove things from that, and so scope can get very, very complicated. And of course, that's a big difference between construction and IT, because in an agile project, you can do, I don't know, you could sprint item 44 first and then do item 43 next, whereas you can't build the second floor of a building if you haven't built the first floor or the foundations. So that's a huge difference, and it makes things quite complicated.
Thank you, Tony, for adding that. And going back to Jonathan, what Jonathan said actually, Jonathan, you said that how the US courts will see is different from how the tribunals will see. And as
No, I think in both cases, Rajat, they'll look at the contract. What does the services agreement provide? Is it specific enough about what implementation will look like for the IT project at issue? We're on common law, jurisdiction, obviously here in New York. New York court will look at this and say, well, what did the parties agree to? I'm going to look at the agreement in the first instance. If there is an issue of vagueness, the parole evidence rules here in the U.S. would allow it. It's an exceptional, way of addressing disputes. They will look at sort of what were the parties' negotiations, what was the extrinsic evidence that would help the court interpret a vague or ambiguous contract. But again, that's the exception. In most cases, the language of the contract will govern.
yeah, and I agree. And I'll go to Sebastian now, and let's hear from him from his perspective from on the tribunal several times. So, Sebastian, when this fuzzy scope reaches the tribunal, so who honestly carries the risk of this ambiguity? Obviously, we agree with Jonathan that the contract model sometimes decides it even before the facts matter. But from your perspective, what do you think?
Yeah, thank you. And I think I can only second what Jonathan and Tanya said before, and Tony touched up on this a bit as well. I think that let me say first, I think nobody tries to draft an ambiguous scope from the outset. So um, the contractual model matters in basically every under every choice of law you choose. It matters how clearly you specify your requirements on construction disputes, the specification, because then later on you have a better chance to not end up in a dispute about what was agreed on. And if the scope is very clear, then basically the only dispute you can have about the defect is was the system delivered properly or not, right? It's not so much about what was the system, what was the promise from the outset. Um, but sometimes it's even if the parties try to draft a very specific set of requirements, um, it's often very difficult to anticipate everything you need in the project later on, right? And as Tony said, it's not like you have this waterfall and you have an ever-changing scope and the project is developing and you do something first that you had planned later on. So it's always evolving and changing. Um, and I would say that if this ends up in front of a tribunal where you have the dispute about what was actually promised and did that change over time because the project changed over time and the parties decided to go another way than what was originally planned, right? Then I can only confirm what Jonathan said, that both parties are exposed. And there is not, unless you have a clearly defined rule under your jurisdiction or in the contract that says party A or B has a burden of proof to show that it was in scope or out of scope. Normally, both parties are exposed because it's often a coin flip. If you have no further information, whether a tribunal will follow you or the other party, because nobody will enter, or at least often the parties will not enter into an arbitration if they think they will lose the case anyways, right?
Right. Agreed.
Yeah,
Very a good point to make.
that's in fact, when you're the service provider, you have to think so many times before you enter into a dispute. You have to do an assessment of your own, of course, with the external counsels, and with an expert also, which itself is a huge exercise. Which sometimes the service provider would think, this is it, if you weigh the output in terms of the payments, what are outstanding payments versus the effort that this will take into prove, because the burden would be on the service provider first. Um, it doesn't go well, then you have to find alternate ways to work that out.
Yeah. Yes. So, Tanya, I would again pick a comment which you made when you were telling us about the scope creep. You said that uh, it's not just the scope, it's how you progress with the scope itself that also sometimes lead to disputes. And I believe that you mean how you monitor the progress or how you track the progress. And then you made another comment that you have personally seen some trackers which record on a very broad level the milestone achievements and all. So on this, I would ask a question to Jonathan from a counsel's perspective, that when a milestone is missed, how do you establish whether uh, the development was genuinely on track or whether the milestone itself was a moving target? Because as Tony said, that in IT disputes, it's a very spontaneous process rather than a construction where you can actually measure or see with naked eyes. But in IT, it's very spontaneous and fast. So how do you establish for a particular milestone?
I would agree. I think with both Tony and Sebastian, it's much different than construction because in construction it's obvious to both parties, whether a milestone was met or not. In most cases, whether a milestone was met or not. In IT, as Tony said, there could be changes in the scope of work, changes in the order of progress, so that the parties may not have a meeting of the minds about what is due at a certain deadline. And certainly with functionality and sort of the features of a certain IT project, there will be disagreements about whether it meets the requirements of the contract. So again, I hate to repeat myself. It really does come back to the language in the services agreement. It has to be as clear as possible. What are the expectations for each milestone? What features of the project need to be implemented at which time? So with respect to SAP, which Tony talked about, that's a common financial reporting instrument for large companies. If an SAP implementation is required, certain modules and certain transaction codes be up and implemented and working. That's one way of determining whether milestones have been met. With respect to more complex projects, for example, I had a large U.S. Case here involving privacy and whether certain privacy requirements were met for the project. There may be certain testing, security testing that has to be done in order to confirm that the privacy requirements of the contract have been met. So there are various ways to test it, but it is, as everyone has sort of agreed, it's a very challenging part of these IT disputes, determining when a milestone was missed.
And can you very briefly comment that you said that it can be derived from the contractual language itself some of the time it becomes very challenging. So why do you need basically experts like Tony to get into these explanations in the contract and to define what is achieved, what is not?
Well, just to circle back to the privacy case, there are certain requirements, basically, whether the data that is collected by the client is confirmed to be secure. So there may be performance testing that can be done at a milestone, and the parties may agree whether it was 70% effective or 80% effective, whether that is in fact the milestone that the parties agree. The parties can avoid those kinds of disputes by at the very outset saying we're going to do performance test after milestone one, and we're going to say 70% effectiveness is the milestone that you need to prove. Shouldn't be a dispute about that. We should know exactly how many accounts are secure. If 70% of the accounts are secure, then you've met the milestone. But if you haven't shown that you've met that milestone, then obviously there will be a dispute among the parties.
Yeah.
Being as
And
clear as
I believe,
possible what's expected. That's the key.
Can I just add to that?
yes.
The
And I believe that's where you get the wreckage in your hand by the councils. And so I want to ask very plainly that how do you reconstruct real progress versus the reported progress after the fact?
I think Tony was going to mention something. Go ahead, Tony.
I was just going to say that one way to get milestones to work better is to have very clear entry and exit criteria. And you touched on that, John, by saying that 70% or whatever in IT disputes, in IT projects rather, it's usually there are no category X defects and only a certain percentage of category B defects and so on. That in itself can cause disputes because very rarely does the client agree with the supplier. But nevertheless, if you've got good entry criteria for a milestone, so we're going to go into this milestone now, we're going to make sure we've achieved it, and the exit criteria are this, then you've a better chance of things going smoothly.
And Tony, let's say you have been appointed by a council, and the dispute is on the milestones itself, the status of the milestones, and the parties say different things. So, what's your approach generally to? I will repeat. Actually, I'm repeating that. What will be your approach to identify what's the real progress, and how would you approach the documents being handed over to you, and what are your general expectations from the documents to construct the real progress?
That's a very, very difficult question because every one is slightly different. But essentially, the key, excuse me, sorry. Sorry about that. Got a new phone and I don't know how to turn it off. That's not very good for a technology expert. The key thing is to get the contemporaneous documentation, which is often emails and increasingly these days WhatsApp messages and things like that. Because if you can put yourself at that point, I always say, particularly with a dispute, as Tanya said, it normally starts when people stop paying, but the real heart of it is when people start to fall out, and that's when expectation and delivery get out of hand. So if your expectation is slightly more than what's been delivered, you're likely to have a dispute. If your expectation is slightly below what's delivered, you're going to have a successful project. And so for me, when I have to go back into to find out if a milestone was met or what happened when, I try and go back to the point in the project where people start to fall out. And then I look backwards and forwards from there. And the contemporaneous emails and messages and all that sort of thing, they're quite key. We did a fairly strange thing some years ago. We actually did a search for expletives in emails because they tell you when people start to get cross with each other. And it's amazing just how often that does get you to that point where somebody says, what the so-and-so, and you think, so that they're now starting to fall out. I know it sounds a bit glib, but it does work. And with a big platform like Relativity or whatever, where we often have 30, 40 million documents. You can't do it without doing some sort of search. So searching for that is often a good place. But that's my answer to that question, to find the point where something was happening. So for a milestone, look at the contemporaneous documentation, because later witness statements and people's recollection will not help you at all. And you're a hostage to fortune with witness statements, because very often one side's telling the truth and the other side's sort of massaging it rather heavily. And if you rely on the wrong one, you can be in trouble as an expert.
Right. And I think that second Tanya's comment that nobody bothers until the money stops flowing in. And I think that is one of the most prominent fallout point in IT disputes. So I'll go to the third issue which Sebastian raised, that the acceptance of the product, which is akin to construction disputes, that sometimes we see disputes around the acceptance only. So on acceptance, Tony, I'll lead with you. And to me, or to us as a layman, acceptance is supposed to be a very clean line between what's done and what's not done as per the specifications. But technically, we see that it's a very blurry line. Practically, I would say, or practically in the disputes. So, as an expert, when you are handed over, you said millions of documents, I would say such a large, huge set of documents. So, how do you prove after the fact whether a system was actually meeting its acceptance criteria when it was actually requested by the provider that to the client that, see, it is complete and please accept it? Tony, I think you are on mute.
Yes, acceptance. Acceptance usually is called UAT, or user acceptance testing, and that's the sort of final part of the process of handing over to a client in an IT project. Possibly slightly different in a construction project, but there are some similarities. The big issue with acceptance testing is trying to do it too soon, and when things aren't ready. And it's probably just worth spending a minute or so just going over the various stages before acceptance testing in software, because it is a little bit different again, and a little bit more regimented possibly than construction, although I'm happy to debate that with somebody. When you're writing software, the first thing you've got to do is test the little module you've written, and it's called unit testing normally. And unit testing is the lowest level. Once you've tested a number of units or modules, you put them together and you test them in an integration testing phase. And following that, your software integrated with its own modules then needs to talk to other bits of software or third-party systems, and that's often called system testing, unsurprisingly. So user acceptance testing has to come after all of that. And there really shouldn't be, and it's never the case, by the way, but there really shouldn't be any defects or serious defects when you get to user acceptance testing, because the purpose of it is to show the user that you've met the requirements, and not that you've got defects in the software. But sadly, that's not, or rarely is that as clean as that. And you often do have user acceptance testing that starts and then has to stop because something falls over, or it's just not working. But the real key to getting user acceptance testing flowing well is to have had what we call in the trade a requirements traceability matrix. So you've got, in a typical IT contract, probably 2,000 or 3,000 requirements, maybe something like that, and maybe a lot more, maybe a few less. And the matrix is quite simple. You just list them all out and you say, have we met that one? And have we met it fully or partially or whatever? It's also very useful for identifying changes and for things that have crept away from where it was meant to be. But if you followed a religious and very tightly controlled RTM, a requirements traceability matrix, and filled it in properly, then when you get to acceptance testing, you're really just saying to the client, look, we've done all this, we've ticked all these boxes, we've shown it you, now we're showing you the whole thing. And you really shouldn't have anything serious at that stage. You often do, but that's just because people haven't done things to the normal process. Again, it's more it's probably more tricky on a waterfall approach because you've got the whole thing there and you're accepting the whole thing. Whereas in an agile, Scrum sprint project, the phases are all individually accepted, and it's the integration of those that you may have a problem with, and ultimately you do need to do a final UAT with the whole thing, but you can individually accept modules and processes and functions much more easily.
Okay. And so, Tony, but we have also seen, I get your point, but we have also seen many times we see acceptance as conditional acceptance, provisional acceptance, acceptance with category A, B, or some punch points and all those things. So I would ask this to Jonathan that uh, we hear that we went live but never formally signed off. So how does this statement, or I would say the rather a whole concept behind this statement works in US litigation or arbitration environment?
Well, I don't think it differs whether it's in a court context or in an arbitration context. I guess one thing as I hear Tony talk, you appreciate how important the experts are in these disputes. You really do need to retain an expert who can explain these terms in very understandable, comprehensive ways for either the tribunal to understand or for the court to understand. A judge here in New York is not going to understand how IT disputes arise and what milestones are reached and when. But somebody who can put it into plain English is very important. And in many cases, these disputes come down to a battle of the experts. The other side puts on someone who will argue that the milestone was met or that the scope was X, and you'll have to refute that with a very strong expert statement.
Okay, that's interesting. But I would say, let's say there's a situation. So, Sebastian, I'll ask Sebastian over that. So, you got a situation where there's a dispute on a conditional acceptance. So, how would you approach that when you see that something was conditionally accepted at that time, but with some reservations? So, how would you approach when there are disputes on such reservations?
Shall I take that one?
Yeah, please, sure.
I'm just reiterating actually what John said earlier, that the contract ought to tell you what to do in those circumstances, because if you get a partial acceptance and there's nothing in the contract that says if you do that then do this, then you're into a Wild West situation where just nobody's in control anymore, because you haven't got a set pattern to get from there. In some big technology projects, disputes I've been involved in, where there's a significant construction aspect as well. I'm thinking of an oil refinery where I was looking at the networking and the SCADA and the control systems. You have a phase after acceptance where you then go into commissioning. With an oil refinery, you're actually introducing oil and using it properly, but you've already been through an acceptance phase. But that's clearly set out in the contract, and that works because you follow what the contract says. But I think if you've got a partial acceptance, as far as I'm concerned, that's no acceptance at all, because you don't have a sign off, and therefore you don't have, and I'm sure Tanya will say, well, the money will stop because you're not going to pay that 20% on acceptance, and then the disputes start.
And
So
what I
that,
see is, just to add
yes,
to
Tanya,
this,
please.
partial acceptance is, what the client generally likes, because you kept him hanging for as long as they wish. They can get all the modifications done in that time.
Okay. So on that, Sebastian, I'll ask you, as a technical expert, Tony gives you a technical answer in a proceeding. And would that actually persuade you as a tribunal, or does something else will move you more?
So if I'm the arbitrator, right?
Yeah.
So so if Tony as the expert or party appointed expert gives me some input on a technical matter, it really depends on what the other expert tells me, right? And then I have to compare both expert opinion. But So I think the question is then, what makes a expert evidence somehow convincing, right? And despite obviously that the whole expert opinion is somehow plausible and that you can, as a layman, understand it, and that's often very challenging, right? That the expert finds a language, and Jonathan mentioned it, that it's basically plain English, right, and not somehow muddied with technical terms that a layman does not fully understand. I think that expert evidence must really answer the question that was posed to it, right? So sometimes you see, I wouldn't say often, but sometimes you see expert opinions deviating a bit from the questions that was posed and that the tribunal is not really interested in. And maybe because of answering this question is a bit more advantageous for the party that is relying on this expert, maybe the external counsel didn't put the question properly, right? So,
Okay.
and as a next
On
step, I
that,
think it's
I have a very. I'll just jump in. I'll get back
yeah,
to you
sure,
again.
sure.
I'll jump in with Jonathan. So Jonathan, what do you will say? How, as a counsel, you appoint an expert, because as our arbitrator Sebastian has told us that I'll weigh the evidence given by both the experts, will gauge it with the existing contractual language or the facts. That's how we will decide which expert has given him a credible answer. So as a counsel, when you engage with an expert, you instruct an expert, you always have an expectations that his evidence gets through the test. So on admissibility side of the evidence, I'm raising a question on the admissibility side of expert evidence. How do you stop a methodology being excluded before the tribunal even hears it?
So it's a little bit different between courts and tribunals. Here in the U.S., we have a case called Daubert, which basically is the gatekeeping determination for an expert evidence to be admitted. But it works similar to how an arbitral tribunal would look at this. First, is the expert qualified? Is this an area of IT expertise that this expert has experience in and has the proper qualifications, whether it's certifications or other such things? Second, has the methodology the expert applied, is it accepted, right? As the way that the expert looking at the information, is it a way that similar experts would look at it? And then the third, most importantly, is the expert applying that methodology accurately to the facts in the case. So you may have an expert who's been asked to look at the IT implementation and asked, basically, did this implementation meet the requirements of the agreement? And that should be a pretty straightforward analysis. But if the expert has no experience in that kind of area and has never done an implementation like this, obviously the tribunal is not going to accept his evidence. If the expert has done it and is well versed in how these work and can explain what should have happened, that will be very persuasive. If on the other side the expert is coming in and saying, well, this was either a change order or there were some other issues from the client that required the IT provider to basically change the system, that expert better have experience with change orders and how things are, how projects like this proceed from the beginning of the project through the completion of the project. So again, qualifications, obviously the methodology and the application of the methodology to the facts at hand.
Thank you, Jonathan. And to our viewers, actually, Jonathan has to leave for some personal
I can stay
errand
for
he
about
has to run.
another 5 minutes.
Yeah, in 5 minutes. So I'll be closing this interaction with panel with three very quick rapid fire redirects, and that to Sebastian, Tanya, and Tony only. And then we'll take the audience Q&A. And I think Jonathan, rest of the panel can take those audience Q&A. Thank you for
Thank
joining
you.
us. Yes, and obviously you can stay for another 5 minutes to listen to those hot seat redirects, I call them. So, Sebastian, there is one thing. If you hear the systems is in daily use but unpaid for, so who is winning this argument in front of you? You are on mute, Sebastian.
Sorry, again, I didn't get the beginning of the sentence.
So the argument is the provider is saying the system is in daily use but is unpaid for. So who is winning this argument in front of you?
It is in use but unpaid for.
Yeah.
I mean, then it's hard to argue that it's defective, right?
Yes.
And then the only question is there an argument to set the payments off by maybe a huge delay or something else, right? But if the system is used, then normally you under most jurisdictions you have to pay for it under most laws.
But what if, as Tony said, that if the contract does not have any allowance or any milestone for partial use or a joint use of the system before it is formally delivered to the
Yeah,
specifications, then
I think normally you have to first look at the contract, and if there's some rule in the contract that says if you use the product, the software, that counts as an acceptance of the certain milestone, right?
It's not always. It's
If
not.
the contract does not foresee, yeah.
okay.
Sorry,
So
Tony.
next
Sorry,
quote to Tanya. Yes, Tony, you were going to add something?
I was just going to say that with software projects, it isn't sometimes that simple, because you might be using it possibly because you've got to, because it's replacing a burning platform. But it might not be running as fast as you'd like. So, the reaction time or the throughput, the volume and performance isn't
Sure.
quite up to standard. So you're having to use it, but it's not quite there. So it can be quite nuanced sometimes. And again, proving that some years later, really, really hard to do unless you've got some stats from some sort of performance tests.
Yeah, sure.
But it isn't black and white. It could be that it's just, it's limping along and you're not very happy with it, but you've got to use it.
Okay.
And
So
maybe you don't have to,
that actually
maybe you
leads.
don't. Yeah, sorry. I just wanted to
Yes,
say
yes,
maybe
Sebastian.
it always depends on what is in the contract and what is codified in the law that you're using for your contract. Maybe that fills a gap that is not put into writing in the contract. But normally, if you have to use a software, you might have to pay for it partially. But maybe you can set it off with the damages you have because the system does not have the performance that you require it to have, right? So maybe the question is very
That's
lawyerish.
interesting. Yeah.
Maybe you have to pay, maybe you don't have to pay. Maybe you even get something from the other party, right? Even though you're using the system.
I get it. I get it. And as a quantum expert, I have seen it a lot more often that you have to actually set it off from the performance criterias,
Exactly.
which
Yeah.
the technical experts have to tell us. Okay, so that actually lead me to the rapid fire question to Tony. That what forensic methods, in your opinion, actually survive cross examination?
That's a very good question. Yes. The key thing of all is to make sure that when you rely on a piece of evidence that it actually stands up, because you can very easily, when you've got millions of documents, you can find that perfect email that says, this just didn't work, or this did work, or whatever. It'll be saying something, and you rely on that. And then in cross-examination, a barrister will say, well, can you just flip the page, please? And over the page is an email that says exactly the opposite with a far better description, far better explanation. And I was nearly caught out in the Four Courts in Dublin some years ago on a screen scraping case where it actually worked the other way around. It was the barrister that was trying to catch me out, and showed me an email that said the opposite of what I'd just said. But I was able to flick through the pages, and on the following page was a later email saying that's completely wrong for these reasons, and then an acceptance. Yes, you're right. I'm sorry. But if I had not done that, I would have just had to have said, well, it looks like I've relied on something that's not right. So you've got to be very, very meticulous in your evidence, relying on things, but testing them and reminding yourself at all times that you are objective. You're there for the benefit of the court and not for your client. And that can be very difficult when you've been living with a client for 2 or 3 years in a big case.
Thank you, Tony. And that leads us to Tanya. So, Tanya, if you have to say, if you could preserve one thing on every project from day one, what would it be?
Some kind of a documentation track. At least now I know there are a lot of tools that are helpful. Again, we cannot maybe get the absolute discussion of what happens, but you can make out from the circumstantial evidences that okay, this was happening and this was implied and this work was done. I'm not saying it's going to get us the entire claim, but it does help. So documentation, definitely. And some kind of a thing that business cannot go ahead with a change request without legal's approval. Something like
Okay.
that.
And very interestingly, there's a similar question from our audience, and I think it's a very convenient and perfect time to move to the audience Q&As. So how I will sail through these questions is I'll put this question to our panel, and one of our panelists will answer, and then I'll take the next question. So we have a couple of questions, actually more than a couple of questions. So I'll start with a question from Mr. Sachin Chaudhary. So he has asked to our panel, in your experience, what is the earliest warning sign that an IT project is heading towards a dispute, and what specific action could have been taken at that moment to prevent it?
I think what Tony mentioned, that when you see there is a gap between the expectation of the client and what you're delivering, if there is a big gap, then you start to sense that this is moving towards a dispute. Tony, if you want to add to this, I do think that is exactly where it starts to shift.
Yes, I obviously agree with that. And the key thing, I think, is to make sure that you're continuing to use the vehicle of the contract to your best advantage. And most contracts will say, if you disagree about something, then try and sort it out person to person in 7 days or whatever. If you can't do that, then escalate it to the steering committee or whatever, and follow the process. And very often people don't do that. They just fall out and they don't report it. The RAG status stays green because they're too embarrassed to switch it to amber or red at that stage, and so the thing gets out of all proportion. And once it gets out of proportion, it's very hard to get it back, because once you've fallen out over something or your expectations been dashed, then it's difficult. But usually a contract rather, will have a very clear dispute resolution process in it, starting with the simple stuff and ending up in an arbitration. And you really shouldn't be going that far. You should be able to sort it out much sooner than that, to everybody's satisfaction.
And yes, and I think that's a very important words to say on dispute avoidance rather than dispute resolution. So on dispute avoidance, we have another question, and I think either Sebastian or Tanya would be able to answer it on this. So have you both got any advice on how to successfully work with an internal tech stakeholder when drafting an IT agreement who continues to provide vague descriptions of scope, requirements, and privacy and all those things?
I can take that one if you like.
Yes, obviously you can. Please.
Yes, well, it's a huge problem when you've got vague requirements, and the key is really to hold workshops with the right people, and if necessary, hold more workshops than you've budgeted for, because it will pay you back in spades later in a project if you've actually got the requirements in more detail. If you've just got a vague requirement that we want it to be faster than our old system, or we want it to be able to do several things at the same time, silly requirements like that can't be measured, and therefore can't really be delivered. And you have to sit down with the subject matter experts. It's always a problem, because in an IT project, and it's probably different from a construction project, in an IT project, all these people have got their day jobs. The clients, they'll employ some consultants, but the people who are going to be using it later have got their day job to do, and finding time to do their day job and to attend your workshops or your training sessions is really hard. So emphasizing just how important that is to them and getting them along to workshops, getting them along to training, you will then start to understand the requirement and you'll be able to put it down. Sometimes you have to do it for them, but you write it down and you say, this is what you mean, and they'll say yes, and you get that into the requirements documentation and ultimately into the contract.
Yeah, and so Sebastian, do you agree with Tony? Because Tony has raised a point that when drafting this kind of agreements, from legal point of view, let's say a client has involved a counsel like you in drafting a IT contract. So would you prefer to have a subject matter expert sitting alongside you in drafting or in helping you drafting the contract?
Definitely, I think it's very important because I'm not a technician. I cannot draft the requirements for you. So most of the requirements I do not understand until they end up in a dispute, and someone like Tony has to explain them to me what they mean, and that's where we circle back to what I said at the beginning. It's hugely important to have the requirements as detailed and as clear as possible, and to as Tony said, if I already notice that they are ambiguous or if there are gaps, then it's definitely not a complete set of requirements. Then you really have to work on it. And that's why it's very important to sit down with the subject matter experts and to draft this kind of contract very carefully.
Yeah, could
Okay,
just add.
so Tony, that leads to another question by one of our viewer. He says that when using agile methods, IT project scope purposefully kept lightweight or broad, and that's how many framework and big fours actually intend to do. How to strike a fine balance both as a client or as a delivery partner in this?
Well, yes, it's interesting. Actually, the same answer applies, but on a smaller basis, because just because something's agile and just because you're going to try and sprint it in 2 weeks or 4 weeks or whatever, doesn't mean that you shouldn't define it. It's just a smaller job because you're defining perhaps 5 or 10 requirements rather than 500 requirements. And you've sometimes got to be bold and you've got to say, look, I'm not sprinting this because I don't fully understand what you want. So go away and come back in 4 weeks' time with some more, detail. And in the meantime, we'll do this bit instead. There are some benefits huge benefits in agile delivery. I'm not such a fan of agile project management, but agile delivery of code is wonderful when you've got a good team. But it doesn't take away from the fact the requirement has to be defined. It's just a smaller job because it's a smaller set of requirements for one sprint or a series of sprints.
Yes. So moving on to the next question, it's quite interesting. Everybody wants to hear the answer to it. So it says, with the rise of AI in recent years, how the landscape of dispute is changing as compared to traditional projects.
Okay. I think the most obvious one, maybe not that specific for IT disputes or construction disputes, where I draw the comparison, is that you have wherever there's a large set of documents where you back a few years ago where you had to run through a whole team of younger lawyers to go through the documents and have this level 1 review. You now have to use AI to have this level 1 review and to flag all the potential smoking guns, and then you only have a real human look at the level 2 review. That's where AI already hits us and where we can use it. And besides that, what I'm interested in is, can you at some point even refine it to a first level 1 review? But I do not see the AI being there yet. Maybe at some point.
So, okay, that's interesting. That leads us to the next question, and I believe that would be the last question for the evening. And so, AI projects often create high expectations, but the delivered solution may not always match what the client believed they were getting. As an expert witness, I think it's for Tony. How do you determine whether there was a genuine shortfall in delivery, and how would you quantify the resulting cost or damages to the client?
Okay. Yes, that's a very interesting question. I think we've probably already answered that in the discussion about requirements and so on. But the AI, I assume this question means that the AI was creating the requirements, possibly. It's not particularly clear to me, but how do I determine whether there was a genuine shortfall in delivery? Well, you can only do that by reference to the agreed contract, the requirements, any gap analysis that's been done, and those sorts of big project documents, whether it's an agile delivery or whether it's a waterfall delivery, you still need to produce these documents, and you can very easily use AI to compare the requirement with what's been delivered. These days, we all use AI a lot, but we all must remember that it's not always right. In fact, it's very often not right. I was arguing with AI the other day, saying that's not the question I asked you because it thought I'd asked something else. And it was very apologetic. It came back and said, "I'm very sorry, I misunderstood your point. Here's the answer." And I mean, we're all doing that, but you have to remember it's not always right. And you have to remember that when you're delivering software, you're delivering it to a contract or an agreement, and you're delivering it to somebody's requirements that were probably carefully thought out when they went out to tender. And you've got to marry those up with the gap analysis you've hopefully done to say, well, we can deliver 90% of that. We can't do this. It needs some bespoke, or you don't want it at all. And AI can be used to mesh those together to see just how well it's gone. But you can't get away from the fact you need the requirements and the contract.
Yeah, and I would jump in to answer the last limb of this question, that how would you quantify the resulting cost or damages to the client when it comes that there was a genuine shortfall in delivery. So it comes to various valuation techniques. First, as Tony said, that you have to gauge what was supposed to be delivered. That's the very first point, starting point, even for the quantum experts. So you have to see what was supposed to be delivered and what was delivered. According to that, you have to create a benchmark of the cost benefits which were supposed to be harnessed because of the genuine delivery of the software, let's say. And then you have to see in the real scenario that what actual performance issues are coming and how the damages are being incurred because of those shortfall of performances or shortfall of deliveries. So these come to the various, sometimes the contracts have predetermined methods or costing rates to identify such damages. Sometimes the quantum experts have to value it basis on the product itself using the market pricing techniques, and there are many valuation techniques, but it gets more difficult if it is the language or the method is not explained in the contract. Yes. Yes, so I think that's it. Uh, for the paucity of time, I cannot take further questions from the audience, and I'm seriously sorry for those whose questions remain unanswered. So moving on to that, I'll thank our panelists for joining us and delivering us a very insightful session today. It was actually important, and I would say we learned a lot. I personally learned a lot from it, even though I belong to the industry. But yes, there were things which I didn't know. I got new perspective, and I believe our audience also has the same view. Then I thank Gar and Mason to put up this event. And yes, very big thanks to our audience who has actually listened to us and has made this event successful. Their questions were quite insightful, and I hope those good answer. They got their answers through this, I would say, a very long discussion we had, but yes, an insightful one. Thank you, everyone.
Thank you.
That wraps
Thank
up
you.
our live session.
Thank you for having us.
Thank you.
Thank you.
That
Bye.
wraps up our
Bye.
masterclass.
Bye.
Thank you all for joining us today. A special thanks to our speakers for their time and effort in preparing and delivering this session. As mentioned earlier, the session was recorded and we'll be sharing a copy of the recording with you in the coming days. Thank you once again and enjoy the rest of your day.
Thank you. Bye.
Bye bye.